Should juvenile courts be abolished? Yes. History of the juvenile justice system. Thomas Eddy and John Griscom were founders of the Society for the Prevention of Pauperism. They established the New York House of Refuge in 1825 to help youth in need and to oppose juveniles being housed with adults. The Illinois Juvenile Court Act of 1899 was the first juvenile court giving it jurisdiction over delinquent children under the age 16. Most of the rest of the country adopted juvenile courts. The court was given authority to use broad discretion on a case-by-case for the juveniles with very little formal guidelines. By the 1950s and 60s, there was public concern for how effective the juvenile justice system was. History continued. Following the public concern, the Supreme Court formalized the juvenile justice system by adding right to counsel and requiring formal hearings when juveniles were being considered for transfer to adult facilities. By the 1980s, the public then felt that the juvenile justice system was too lenient. This began the start of the well-known "get tough" era for the juvenile justice system. The punitive trend followed into the 1990s, where the U.S. saw a large increase in juvenile offenders being confined for minor offenses or being incarcerated in the criminal justice system depending on their crime. The rise in juvenile offenders caused many states to take a deep look at the juvenile justice system. Although many states wanted to reform it, a broad change or reform has not been currently accepted. Our thesis. Although the juvenile justice system aims to protect juveniles from the adult court system, the get tough attitude in the current juvenile justice system is too similar to the criminal justice system. According to Taking Sides, page 90, in the Kent versus United States case of 1966, the Supreme Court said juveniles are not being given the protections given to adults, or the regenerative treatment given to children. This was after some reform had already taken place, and before the Get Tough era started. Our goal is to outline why the current juvenile justice system should be abolished. Differences between adult and juvenile courts. Juveniles receive different procedural safeguards than adults. Adult criminals are protected under the Sixth Amendment. This includes right to a fair and speedy trial, right to receive representation, right to a jury of one's peers. In juvenile courts, individuals are not offered these same protections. The trial process tends to be informal, since courts are not required to follow due process. Juveniles are allowed representation, but many individuals unknowingly waive that right. Judges are allowed to appoint counsel, but the distribution differs between urban and rural communities. This is called justice by geography, where living in a rural area may afford less protections in the trial process. Juveniles are sentenced by a judge and do not get to appear before a jury. This leads to juvenile offenders serving harsh sentences well into adulthood, even though they were never afforded a proper trial process. We will now look at some landmark court cases. In the case of N. Rigault of 1967, it was established that fundamentally fair practices should be available for juveniles. This includes the right to a fair and impartial hearing, advance notice of charges, the right to have counsel, opportunity to examine witnesses, and protection against self-incrimination. This case was important for recognizing the juveniles were at a disadvantage since they were not receiving protections afforded to adults. Another case, Enre Worship of 1970, increased the standard of proof from preponderance of the evidence to beyond a reasonable doubt in juvenile court proceedings. This helped ensure that juveniles were only receiving sentences if the judge is positive they committed the crime. Looking at some more court cases, we see McKeever v. Pennsylvania of 1971 declines the rights to juveniles safeguarded by the Sixth Amendment. It did not require a jury in criminal court proceedings, determining that the right to due process only ensures accurate fact-finding in trials. This prevents juveniles from receiving the same benefits as adults, while still allowing them to receive the same punishment. In another case, Miranda v. Arizona, 1966, granted protections against self-incrimination, allowing juveniles to waive their Miranda rights and the right to counsel. Since juveniles have been shown to exhibit a lack of judgment, they should not be held to the adult standard of waiving their rights with knowing, intelligent, and voluntary consent. We will now look at the anti-abolishment of the juvenile justice system. Other views of the juvenile justice system say that it should remain in place because there is documentation that the executive function is not developed until our early 20s. With a developing executive function, judgments are not the same as they will be in an adult. Executive function is defined as the part of our brains that is responsible for judgment and decision-making. As it develops, also is in charge of impulse control. The executive function is one of the main reasons why a child's brain is different than an adult's. Rebuttal and counter-argument. When we look at the demographics of children in the juvenile justice system, or JJS, we can see the profound effects of abuse, neglect, poverty, and domestic violence. These are all factors that can negatively affect executive function development. This also compounds the problems for the juveniles. Juveniles simply are not adults, and need to be treated differently. The current juvenile justice system does not adequately separate the two. The juvenile justice courts and systems need to be focused on rehabilitation. Given the statistics of abuse and neglect of juvenile offenders, the programs they should be a part of the juvenile justice system may be the first time they have been shown how to make healthy life choices and actions. The therapies provided to juveniles would also give them a chance of becoming productive citizens rather than just inmates. Counter-arguments continued. The abolishment of juvenile courts is imperative in order to correctly develop the children of this country. The children hurt most by juvenile courts are those who are of a lower class and are in real need of education, nutrition, and most importantly, a good role model to care for them. Currently, juvenile courts punish these children by surrounding them with other troubled teens that teach them worse activities. Our goal as a society should be to improve these children's behaviors that are still rapidly developing than to punish them without teaching them anything. Counterarguments continued. We have laws in place that protect children from their own immaturity, such as driving age and alcohol age limit. So why don't we do something similar with these troubled teens? Rehabilitation is the key to treating most children. In Taking Sides, page 96, a little boy named Anthony was hungry and in an act of desperation stole the money from another boy. This gives us a tiny bit of perspective into Anthony's life. Instead of being helped or rehabilitated, the boy was punished in adult court and would have been punished similarly if placed in juvenile court. Children need guidance, not just punishment. In conclusion, to say that we are arguing for the abolishment of the juvenile justice system might sound like we hope that all juvenile offenders should be tried as adults and that there should be no difference. That could not be further from the truth. What we are advocating for is a total reform of the way that we handle juvenile cases. Our troubled youth should have more protection, more assistance, and more chance for rehabilitation and learning. The juvenile justice system, as it stands, focuses far too much on punishment. What we would like to see is a system that asks, what can we do to intervene and improve the life of this child? Instead of, how severely should this child be punished?